Hello everybody. So in this presentation, what we're going to look at is student publications. Now this somewhat goes along, as you'll see, with earlier when we talked about free speech, because at some point uh, students are going to claim that their right to put something in a school newspaper, or maybe not even a school newspaper, just something that they are distributing themselves, is a right to freedom of speech. And so they're a little bit together, and you're going to see some overlap in that, and especially when we get into the big case that deals with student publications, you'll see that overlap. Okay, so let's start off here. So first of all, Tinker has been applied to this type of case a lot, and not just Tinker, but Bethel and Kohlmeyer as well. But Tinker in the sense of disruption, okay, the foreseeable disruption that may come of a publication. And so we're going to see cases where Tinker would apply. And then Bethel, certainly a school is going to have a right to step in if there is some questionable language in the publication, and we saw that in the Bethel versus Frazier case. And then the Kohlmeyer case we're going to discuss the most here in a second, so I'll leave that one. But I wanted again to point out here, this is a quote out of the Bethel case where the court explained that the First Amendment rights of students in the public schools are not automatically coexistent with the rights of adults in other settings and must be applied in light of the special characteristics of the school environment. So in other words, what we see the court doing when it comes to publications specifically here, but in general, again, students as a stakeholder in public schools, is the court is constantly weighing the rights as a citizen versus the rights as a person in the school. Okay, and it's going to be that line that we go back and forth on. And Alexander in your textbook point out that when it comes to publications, this is one of the areas where the courts really are divided in many aspects. And so as a result, we're going to end this brief presentation by talking about policy and what you need to put in your policy to protect you and make sure your policy is up to date. So when we talk about freedom of the press, we're not going to go back to early American history. We're going to start here with New York Times versus the United States. And this is the big case dealing with the Pentagon Papers and the Vietnam War and Richard Nixon. And the question here is, can the government suppress information? And in relation to schools, of course, the school is acting as the government entity. So that's our big question here. In the New York Times case, the court stated, in the First Amendment, the Founding Fathers gave free press the protection it must have to fulfill an essential role in our democracy. The press was to serve the governed, not the governors. The government's power to censor was abolished so that the press would remain forever free to censure the government. So that's in 1971, certainly stating that the government cannot censor the press. So then out of Frazier, we are reminded of what I just said. So that was in 71. And then out of Frazier, we're reminded again that the First Amendment rights of students are not automatically coexistent with the rights of adults. So even though we see the government is going to strictly rule in favor of freedom of the press when it comes to adults and students, we're going to limit that. Okay. So where that limit comes in is what the courts are somewhat divided on, but there are some general guidelines that we're going to see. So first of all, there are three categories of publications which we're discussing here. The first one are school-sponsored newspapers, and that's going to be the easiest to deal with. The second one is non-school or underground newspapers written and distributed by students. And then finally, the third area is materials distributed by students but written and published by non-students. And at some point, I believe that we're also going to get into the religious aspect and religious materials as well, because this material, typically what we see under materials is going to be motivated by religion. Not always, but typically. So our case here that we're going to go back to dealing with analysis. So keep in mind that when I was talking again, back to the analogy of the tree trunk, there are lots of things that go into a court's decision. And when you look at a court's decision, they're going to reference all kinds of cases. So they're going to bring all things together. So anytime you look at a court decision dealing with speech, you're most likely always going to see obviously the 14th Amendment, the First Amendment, and then you're going to see the same cases repeated over and over. And when it comes to speech in schools, you're going to see Tinker, Bethel, and Kohlmeyer. So the reason we go all the way back to 1939 is this is the first time that we see the introduction of forum analysis. Okay, so Haig versus CIO, 1939, identified the notion of a public forum. And this is going to tie into schools and the ability of school administrators to work with school publications. Okay, so stick with me here. I promise we're going to get a connection. We don't need to know the background of the case. Just understand, again, this is the base of that tree trunk for forum analysis. So the court in Haig, 1939, identified the notion of the public forum. So forum analysis takes three areas here. Okay, so the first area is, and what you have to do is decide what where the government fits into this, whatever the government entity might be. So here we're talking about schools, but so the court is going to decide what type of forum the school is. And here again, the term forum means a place to speak. Okay, so you have three types of forums. The first one is a public forum. This is open public areas, parks, and sidewalks. Okay, so this is why you can have people in a public park get up and say whatever they want to say. This is why you have protected speech on the Mall in Washington, D.C., because that is a public forum. Okay, it is protected speech, and if the speech is to be limited, there is going to be strict scrutiny by the court. And here, strict scrutiny means that the court is looking at a law that was passed to limit speech in some way, and that law has to have a compelling government interest in order for it to exist, and that the law is narrowly tailored to get at just that specific government interest. Okay, so there's a lot of strict scrutiny here to try and limit speech in a public forum. Okay, it is a very protected area. It's the most open of all the types of forums that we're going to see. The second type is a limited public forum, and here the state, and when we say state, we mean the government. In our case, we're talking about the schools, the school district, opens property for public use. It is, again, protected speech. And again, the key thing here is strict scrutiny. Okay, so we're going to get into the question of what part of education is a limited public forum and which part of education is a closed forum. Okay, so in a closed forum, this is not open to the general public. Reasonable restrictions in speech are the rule, and your text makes a distinction, especially between elementary and middle and high school students, so that elementary school students exist in a closed form. Laws are going to apply differently because of the age of students, and so in elementary school, there's not a lot of debate. They're closed forum. It's when we get into middle and high school that we move from a closed forum where a school chooses to make itself a limited public forum that we start seeing some issues arise. And again, a lot of this can be addressed through policy, but it also takes a level head to work through the various situations that we will describe. So now that we've looked at Hague and we see that the court has defined forum, and we get the basis of forum analysis. That was 1939. Push forward almost 50 years, we're going to get to Hazelwood School District versus Kohlmeyer. And in this case, the court heard of a principal who the school had a newspaper, and the students had wanted to publish 2 articles that the principal said were not appropriate, and had told the students they could not publish the articles. And so what's going to happen here is that number one, the court allows school administration to control or censor school-sponsored newspapers. Okay, and we're going to get this through the type of forum that we will see. The court also ruled that the district has broad authority to regulate other types of expressions as well. School officials have broad discretion to prohibit student articles that are ungrammatical, poorly written, inadequately researched, biased or prejudicial, vulgar or profane, or unsuitable for immature audiences. So this is what the courts ruled in the Kohlmeyer case. They're saying the district has the right to censor school-sponsored newspapers. Hazelwood allowed school officials to regulate student expression for a legitimate educational concern, including the choice of music even. And so it's under this ruling that you as an administrator could say, and this is something that could very well happen to you. Maybe you're chaperoning the prom, you're the administrator in charge, and you hear some vulgar music come on that the students are playing from their iPods that they've plugged in. You have a right to go up and say, absolutely not, we're not going to hear this music because of the language here. Okay? And so Hazelwood or Kohlmeyer is the court decision that gives you the right to do that. So what about underground publications? These are publications not school-sponsored. Kohlmeyer worked with school-sponsored publications. What about those that are written by students? So here we see Hazelwood does not apply. And what we learned is that schools cannot censor these newspapers. So this is where policy really, really becomes important. Here, Tinker is the standard. Okay, actions can be curtailed if there is a reasonable forecast of substantial disruption. And so, it has to be more than just that you disagree with something that's being said. There has to be this reasonable forecast of substantial disruption in the school in order for you to not publish an underground newspaper. We call this prior restraint. Okay, and this is an important term to understand. Suppressing speech before it is uttered, as opposed to punishment of individuals after the expression has occurred, is called prior restraint. And the courts are very reluctant to grant prior restraint. In looking at form analysis, what we see is the age and maturity of students is the key in the courts allowing this freedom to use prior restraint. And as I was saying earlier, it deals specifically with elementary schools. The courts have ruled elementary schools are not open forums. Therefore, whether it's a school-sponsored newspaper or whether it is an underground newspaper or material that a student is bringing, and you might have this in an upper elementary school. Elementary schools are not open forums, and therefore prior restraint is not an issue. The school can just say, no, it cannot happen. Where it becomes an issue, though, is when you get into middle school and secondary schools, where you have these underground newspapers or materials that are not sponsored by the school. And then in order for you to suppress the material, you are issuing prior restraint. And here's where the court is really saying Tinker has to apply. So a couple of court concerns about prior restraint is, number one, a regulation that places unbridled discretion in the hands of government officials constitutes a prior restraint and may result in censorship. Here what the court is saying is we're getting at that policy question. Your policies have got to be specific. They cannot be so broad that it gives you the right to just censor everything. Okay. And number two, regulations that do not take place, time limits within which the official must make a decision as to whether the proposed publication is allowable. Again, we're going to talk about what has to happen as far as policy, and within that, you're going to have to put regulations on how you're going to handle this material when it comes to you as a secondary administrator. Okay, so the third level then, so that's kind of, we're talking about the three levels. School-sponsored publications was number one. Number two was non-school sponsored publications. The third area is students distributing things from outside the school. Okay, and then within this falls religious materials. Generally, there is no distinction between student-distributed religious publications and other non-sponsored materials. Schools may impose reasonable time, place, and manner restrictions on non-sponsored expression. Schools may restrict distribution of non-school publication to designated areas of the school, excluding halls and classrooms before and after school and during lunch periods. In other words, if somebody wants to distribute the Gideon Bibles, or if a student wants to distribute material from outside, through policy, the school can dictate exactly how that is going to happen and where it will happen and the manner in which it will happen. School officials open to the school to indiscriminate use, then the school becomes a public forum, and a limited public forum may be created. Thus, denial of the right to distribute religious material may be unconstitutional. So here's the key in all this. Okay? The key is that schools start out as a closed forum. When the school introduces somebody from the outside or something that's non-curricular related, the school then moves into this limited open forum or limited public forum. And at that point, the school has to be content neutral on its decisions as to whether allow other groups to join or other organizations to form. So this is really where we see if the school allows the Gideons to distribute religious material in the cafeteria from 12 to 12:30 during senior high lunch, then the school has to allow any religious organization to do the same thing if they wish. Okay. The same if a school allows a non-curricular organization such as the chess club, and we talked about this in freedom of speech a little bit, which is non-curricular related, to have meetings after school in one of the classrooms or during lunch, then if an LGBT club is organized, the school has to allow that club the same access that it allows the chess club, or maybe it's a different religious group. If there's a fellowship of Christian athletes that forms and the school allows this, then if there were a group of fellowship of Muslim students, then the school would have to allow that group as well. Or the fellowship of atheist students, the school has to allow that as well. Okay, so that's the key here when we're talking about form analysis. And the big point I want to take away is that's what happens when schools open themselves up. And all schools do. You can't not do that. So here's where you have to use your intelligence and personnel skills to work through some sticky issues, because you cannot break the law as the school district and deny somebody just because you don't agree with them. That's the content neutral piece. If you allow one, you have to allow them all. Okay. So anyway, that's form analysis that comes out of Hazelwood, or Kohlmeyer, as I've been referring to it. It's the same case. And that's really the issue here when we're talking about school publications or student press. School publications under form analysis are considered to be a closed form. It's when we get outside of school publications that we get into a limited open forum, and that's where judgment really comes into play. So let's review just a few things here, and then I'm going to give you some guidelines for policy, because again, the courts are a little bit over the board on this. And so the main thing that Alexander and Alexander say is to put it in policy. So before we get to that, let's do some review. Of the three categories of publication, which is the only one that school officials have broad discretion to regulate: student distributed papers written and published by non-students, underground newspapers written and distributed by students, or school-sponsored newspapers. And as we just said, that school-sponsored newspapers, the courts have ruled that school-sponsored papers are a closed forum. To suppress speech before it is uttered or opposed to punishment of individuals, to suppress speech before it is uttered, as opposed to punishing individuals after the expression has occurred, is called prior restraint. Of the following cases, which decision allows for dogs to be used in exploratory searches of lockers in Oklahoma? That is the Samora case, and that has nothing to do with what we just covered. So I'm not sure why that question is in there. Just a little bit of review. This is going way back to the beginning. The difference between an independent school district and an elementary or dependent school district is grade offerings. In Oklahoma, it's the grade offerings. Dependent, in order to be an independent school district, you have to go to 12th grade. So all these other things may or may not be. It's grade offerings that ultimately decides the dependent and independent in Oklahoma. You're the principal. You discover an underground newspaper. You may censor the paper without the presence of potential disruption. False. This is the limited open forum, and Tinker does apply here, and you have to have that idea of substantial disruption before you can censor the paper. According to New Jersey, this is a little bit of a review. New Jersey versus TLO, students in school environment have a lesser expectation of privacy than in the general public. This is true. We're going to see that, even though I said it's review, we're going to cover that in the next one, I think. We'll cover TLO in another chapter. So don't worry about the TLO questions. We'll get them in a couple of weeks. So some guidance out of your book dealing with student publications. Number one, the First Amendment does not guarantee the right to communicate one's views at all times. Number two, nothing in the Constitution requires schools to give access to all who desire without regard to disruption. Number three, if the school is considered to be a limited open forum, then content-based censorship cannot prevail without prevailing interest shown by the school. So in other words, what they're saying here is once we get to that limited open forum, which we are there, then you cannot use content-based censorship unless there is a prevailing interest, and you have to be able to demonstrate why that prevailing interest allows you to censor based on content. You have to be content neutral in allowing publications at school. Number four, with a limited open forum, as I said, we're there in secondary schools. School authorities can regulate speech. They do so by regulating the time, the place, and the manner of distribution. Okay. Restrictions have to be viewpoint neutral and reasonable and pursuant to the school's purpose. So here's some things that you have to have in policy. In other words, it's not that you can't deny it, but you can regulate it. So number five, school policy can require students to submit material before distribution. Disapproval may be justified if, so number four is talking about speech. Five, we're talking about prior restraints. So when can schools use prior restraint? Tinker, number one, reasonable forecast of disruption. Number two, Bethel, potentially offensive. Libelous or violates another's rights to privacy if it's false or misleading, if it's disparaging or demeaning to a race, a religion, a gender, or an ethnic group, if it includes true threats or implied threats, or if it suggests or encourages violation of law. In any of those instances, schools can freely use prior restraint. Other than that, it's tough for a school to issue prior restraint. Okay. The last few things here. Number six, whatever the school does in policy, you must have the ability for students to appeal a decision to a higher level, and finally to the school board. In your policy, you must define what the term distribution means. Does this mean passing out flyers on the sidewalk? Does this mean passing them out in the hallways, in the cafeteria, at lunch, in the hallways before school? You have to define all these things. The place of distribution should be specified in the manner prescribed. And then finally, and again, if anything that this chapter shows you, your policy has to be in place and up to date. And so you hear me harp on it all the time. Policy, policy, policy. Make sure your board policy is up to date. Okay? And that's you as a principal can do that and go to your central office or your superintendent and tell them they need to update policy regarding student publications.